All right, looks like we have a full board here. All right, I see Mr. What does the little white hand mean on the screen when somebody has a little white hand showing?
It means they're raising their hand to ask a question or something
Oh.
like that.
Is that what that means? But that person's muted. All right, I'm going to start the meeting, and if that comes up, we'll deal with it then. All right, I'd like to welcome you to the Woodbury Zoning Board of Appeals meeting. Please rise. We're going to do a pledge to the flag, even though there might not be a flag. Oh, Joe has a flag, so we'll do Joe's thing. I pledge allegiance.
Pledge allegiance to the flag of the United States of America and to the republic
for which it
stands,
one
one
nation,
nation,
under
under
God,
God,
indivisible.
indivisible,
with
with liberty and justice for all.
Thank you. This is the Woodbury Zoning Board of Appeals meeting. We meet the second Wednesday of every month. Our next meeting will be on June 9th. I'd like to introduce our board at this time. We have Mr. Joe DiVenuto. I don't know if your pictures are the same order as mine, so I'm going in the order of the photos. Probably not. All right, Mr. Joe DiVenuto, you could raise your hand. Mr. Kevin Abrams, Mr. Andrew Zumas, Mr. Craig Brady, and who did I forget here?
You.
Oh, me, right. And I'm Karen Unger. Our recording secretary is Jess McLennan, and our counsel this evening is Mr. Rick Golden. Let's go to the agenda. We have no executive session this evening. Has everyone read the minutes from April 8th?
Yes,
Do we have a motion to accept those minutes?
I'll make that motion.
Second.
All right, all in favor? Aye.
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 Right, thank you. All right, new business. We have two items on the agenda. The first one is VITE, discuss letter received requesting extension. This is an application for a variance that was approved back in 2019. The applicant requested an extension due to various circumstances, COVID, death of a lawyer, etc. 90-day extension was granted in July of last year. That expired in October. And then in April, the applicant requested another extension. And unfortunately, despite the, at the last meeting, we wanted to know if we had the authority to actually grant another extension. Unfortunately, despite the extenuating circumstances and taking into account the extension provided for the COVID-19 pandemic, the board is limited to granting only one 90-day extension to any applicant. And so therefore, we cannot grant a second 90-day extension.
If I may, Chairwoman, I do think that that's a misinterpretation of the law. There was a request made for an extension
Okay.
September 9th. And it's my understanding that the law basically would require an extension granted when there's no change of circumstances for the factors that require or that the original application was granted on. There's been no code changes. There's been no environmental changes. There's been no changes to my client's property or to the neighborhood. And there was the extension request back in September 9th that was not granted. For those reasons, I believe that the law actually squarely requires that the board grant this extension. If the board's not in a position, if it doesn't feel that that is correct, then I will be forced to file an Article 78 application.
Mr. Golden, could you weigh in on that?
Quite frankly, I didn't read anything on VITE. I didn't realize that that was on here for any substantive matter. I thought this was,
I can weigh in if you
go
want.
ahead, Kelly, thank you.
Oh,
Sorry, I'm here. I was tagging Rick out, but I was just eating some dinner since I showed up a little late. Justin, I did the research on this, and this isn't something that the board has the ability to extend it longer than the one extension. It actually expired after your July extension. Now, that doesn't preclude you from reapplying, and like you said, the situation hasn't changed, but the board would still need to go through the process. It's just that the village's code itself specifically limits it to only one extension, which was granted by the board.
No, I understand. I think I disagree with you on the reading of the law, but I will contact you to discuss it because that may be I'm looking for an efficiency here, efficient way of resolving the problem. So if the most efficient way is for us to make the reapplication, that's what I'll recommend to my client. But yes, so I'll give you a call maybe in the next couple of days to discuss that then.
Okay, that sounds good.
All right. Do we need to discuss anything further on that?
No, I think you're all set.
All right. Thank you so much. Thank you, Mr. Kimball. Thank you, Kelly.
Thank you for your time.
So Rick, I'm here now. I'll tag you out. You can go home. Thank you.
All right, well, it's good seeing everybody and meeting some of you, and I'm sure I'll see you again.
All right. Thanks,
Thank you,
Rick. I
Kelly.
appreciate it.
Thanks, Rick.
Thanks. Sorry. I was picking my parents up at the airport, so I was a little late.
All righty. That's okay. We've got counsel. That's all that matters. Thank you so much. All right, next on the agenda for new business is number 17 Blueberry. This is discussing the memo from the building inspector. This was an applicant who back in, I believe it was 2020, February of 2020, was granted a variance for various setbacks, etc. And variance was approved. And when they decided to move forward with the construction, they decided to make some changes. The applicant submitted a new drawing to the building department, and the building department wanted to know, is that enough for them to grant a building permit? However, it's not because the original decision was based on the drawings that were given. And now that the plan has changed, the applicant will need to submit a amended application. Is the applicant present? Mr. Eckstein, is that you?
Yes.
Oh, okay. You would need to submit an amended application with the new drawings and a new application, and we would revisit that in the future, at a future meeting.
Okay, but even if we do not do any changes to the setbacks and
Right, right, because the decision was based on the drawings that were given, and since the drawings have changed, that's the reason that we need an amended application. Where did he
Okay.
go?
Mr. Eckstein, the decision specifically referenced those decisions within the text of the decision. So the decision would need to be amended to describe exactly what you are proposing in the new plans. That makes
so
sense.
it will have to go through the full zoning board again, I guess.
Yes, yes.
Yes.
Okay.
All righty. Thank you, Mr. Eckstein. Do you have
Thank
any
you.
further questions?
No,
All righty.
thank you very much.
All right, thank you. All right, we have no action on decisions. So we'll move to the public hearings. The first one is Abraham, continuation of a public hearing for an area variance for the demolition of an existing non-conforming 3-family dwelling and reconstruction of a 2-family dwelling, whereas pursuant to section 310-43.2B, number 3, a non-conforming use cannot be changed to another non-conforming use, and per village code section 310-43.2, letter C, a non-conforming use cannot be expanded without zoning board approval. Furthermore, per village code section 310-7, the minimum lot size is 2 acres and 0.48 acres is provided. A rear yard setback of 50 feet is required and 45.06 is provided. A side yard setback of 30 feet is required and 15.45 is provided. This property is located on a private road, and as per village code section 310-8, all new construction must be located on a state, county, or village highway or street. Said property is located in the R2A zoning district at 14 Skytop Road in Highland Mills and is known on the Village of Woodbury tax maps as section 217 Block 3, Lot 5. Is the applicant present? I'm looking at my pictures here.
Hey, Myro. On behalf of the
Oh, there
applicant,
you are. I'm sorry. I have to look through the whole screen to find you. Okay.
okay,
So basically, you're asking to either rebuild, to tear down the building that's there and either rebuild it on the same footprint with a 10% expansion or move it to the rear, which would require, setbacks, et cetera, along with the road and all those other variances that you are seeking. At the last meeting, we requested advice from council as far as, what exactly we had authority to do, what exactly shouldn't be done. And basically, the 10% expansion is allowed, whatever. The problem here is either relocating to the rear of the property would create a new building, which would then, it would be non-conforming. In other words, if you move that building, it has to be to a conforming use, which would be a single family dwelling. The code also specifically prohibits enlarging, demolishing, rebuilding, et cetera, all the things that need to be done that you're requesting. However, you submitted several other decisions for variances that were granted, and as far as precedents. I'd like to open this up to the board, unless you have something to say first, Mr. Myro.
well, number one, the area variances you mentioned before would only apply if you took the alternative that we submitted where the building would be moved back. Otherwise, we wouldn't need variances to get the 10% expansion. Second of all, as I pointed out at the last meeting, 31043B does allow for non-conforming buildings to be remodeled or reconstructed. So there is at least some language in your code that a demolition and reconstruction would be permitted. That on top of the precedent, which I believe we'll discuss later, I think it puts us squarely within what's been permitted before. So my understanding that, if I can cut to the chase here, moving it back is not going to be an option.
So basically, you're looking now just at demolishing and rebuilding on the same footprint with a 10% expansion.
Correct.
Where in the code do you see the ability to demolish, remodel, rebuild without losing the non-conforming use? Where do you see that?
310, well, it doesn't say that. It just says that 310-43 says that B says that a non-conforming building may be remodeled or reconstructed, provided it doesn't create any new non-compliance. That's not permitted in the code. The 10% is permitted. So it's not, the language there is language that says a non-conforming building may be reconstructed.
Okay, I have letter C here.
So I think during last month's meeting, that was one of the conversations we were having with council. What is the scope of the non-conforming building? Does that protection outlast the demolition of that building? And we were between council not necessarily agreeing on what is non-conforming. So Kelly, do you have an opinion on the non-conforming protection and where it ends?
So I do. I'm aware of, and based on, so I watched the video of your meeting last time. So I did have conversations with Mr. Myro as well. I know that during the end of that meeting, it was, there was a request to have the council speak to each other. So I did speak with Mr. Myro on this, and we did talk about this section. So this section specifically says that it can be torn down and rebuilt. However, there's also another section that it says that shouldn't happen if it's damaged by fire or other causes, which, time and deterioration, to the extent that, 50% or more of it, it's fair market value, et cetera. You guys can see that part. Won't read it to you because I'm sure you've studied this section over the last few meetings going over these applications. But in our opinion, you're demolishing it entirely and rebuilding. So that is taking away more than 50% of its value, so that the more restrictive provision would apply. However, as I had informed this board in the memo, your prior council, your two prior councils ago, had the same position on the applications that were pending before you, which include Falkowitz, which is the property, as you know, that is right next to this one. So while we agree with the advice of that council saying that supporting the building inspector's determination that once you demolish it, that protection is gone, we recognize that this board actually recognized in that decision that they could do that even though the protection would normally be gone. You allowed them to tear it down and rebuild anyway. So I don't know if that's any clearer. We believe that the protection ends, but we recognize that this board has said, even though the protection has ended, it can continue if you demolish and rebuild, and that you have the ability to expand that by 10%.
So, Madam Chair,
Mr. Stein, is you got to flip your camera around because now I'm seeing myself. Okay, thanks.
Did you have something, Andrew?
yeah, I'm just curious if it's possible the board made an error on a previous precedent. What is our responsibility moving forward? So I don't know if Madam Chair or Council can weigh in on that.
Sure. Well, as you know, this board, any decision that you make has precedential effect. So you have been, and Mr. Myro provided you with decisions that took that into account and said, here are decisions where you have found this way. So whatever decision you make, if you determine that that decision was incorrect, you would explain why, and whatever decision that you make now, you would have to have that decision carry forward. That would be the new precedent. It couldn't be, well, we were wrong on this one, but the next one go back to it. So it really wouldn't be able to be like that. You have to consider this application for what it is, consider the precedent that you have on virtually identical applications, and then move forward using that precedent, whether it's what you've already done or whether it's something new. I feel like Craig's giving me a high five or raising his hand. Okay.
Oh, there he is.
Raising my
Go
hand.
ahead, Craig.
Oh, okay.
Would another possibility be, since the precedent was set with the next door property, and given their proximity, to come to a similar decision, and in almost the same breath request the village board of trustees to clarify the language of that section of code, that if their intention is to truly sunset uses that are essentially no longer deemed appropriate within that zone, then to clarify it and make it explicit.
I think that is a great suggestion. I was on the phone with Mr. Myro for some period of time where we discussed how there are conflicting provisions in these specific sections. And I think that's part of the point that he's trying to raise. So I think it's important to raise to the board. It doesn't have to be within this decision. I can
Right.
bring it to the board, to the board of trustees if you'd like. But I think it is important, if you're getting a lot of these applications, I'm not sure if you are, but to have some clarity as to what the board of trustees intends going forward, and try and make it more clear for this board
Correct.
to act.
Because we wrestled with this at the next door property over the course of probably too many meetings, as Jay might recall. And it was not particularly clear to any of us, but we came to that decision that it was reasonable to allow the demolition because of the state of the building and the foundation, but to allow them only to build over the same foundation and allow the 10% increase. And essentially, that is what, not essentially, that's exactly what it appears Mr. Myra is asking for at this point, given that the option to move is essentially off the table.
Kelly, how would
So-
that affect, how would this, if this was brought back to the village board to clarify this issue, how would this affect the precedent? In other words, we're just perpetuating the same decisions. If they change the code, would that be something different, or would we just have to rely on the precedent that we're setting?
I think that's a very good question. So if you went forward with this application as you did in Falkowitz, you would put, I think the same language would be appropriate within your decision that you have in Falkowitz. But if the village board changed the law, hopefully it would correct these inconsistencies so that, you know, there's one provision that says you can demolish and rebuild and another that says you can't unless X, Y, and Z. So the goal would be that you wouldn't be placed in this situation again, because you would try and remove those provisions. Now, that doesn't always happen. We can't always predict the applications that come in. I'm sure Jay would agree with that. People are pretty creative and they'll come in with different applications and we can't predict everything within the law. So we would try and correct that. But I think it would change the situation that you're in right now for sure, because you would have different, hopefully more clear provisions to apply rather than having to go back to what is there right now.
And would that enable us to set a new precedent?
Yes, well, depending on the application that's before you. But
Right,
it
and the
should.
wording in the new code, if it was changed, the wording in the new code.
Yeah. And you would try, I mean, as you do right now, you try and make every application that you have and every decision that you have as unique as possible so that it really applies to that specific situation. So you would try and do that with whatever the next application that would come in would be. And it would be different provisions of law if the village changed those that you would be applying. So it would naturally be different and you would be setting a new precedent.
Any comments from the board? Any other comments from the board?
I think that's a great idea myself.
Yeah, I mean, it doesn't impact what's before us because a new law could take a year. Right?
Yeah, and then
We
and then
can't
the
wait
way
on a
to
new law.
clarify
We have
this.
to make the decision.
We've had this time and time and time again, this non-conforming.
I think that's one of the reasons we spent so much time, because we were unclear.
Right. So, I mean,
I know-
I'm good with that. I think that that's something we should do.
Jay?
All right, so number one, Kelly is correct that I believe that there's some ambiguity, some conflicting provisions in your section of the code. It probably could use some work. I think it's always appropriate for any board to recommend to your legislative body to take a look at your legislation because you have particular concerns. But I would also agree with Mr. Brady that it shouldn't be impacting what we do on this application. We don't have no indication that the village board may or may not even consider legislation, and I don't think it's going to really impact what we're doing here. Second of all, the conflict that Kelly pointed out between 31043B1 and 2, where you have one says there's an unlimited right to reconstruct or remodel. And then number 2 says you can reconstruct and remodel, but you got to have less than 50% fire damage. They may be conflicting provisions, but one doesn't say notwithstanding the other. They're just two conflicting provisions. I don't think this board gets to pick and choose which one may or may not apply. One of them says you can reconstruct a non-conforming building. Reconstruct means basically tear it down and rebuild it. It doesn't just say reconstruct, it says remodel or reconstruct. So that's a difference. The third thing is with respect to the precedent. There's a couple things I'd like to point out regarding that. Number one, the board always has the authority to correct a precedent that was made in error. But there's a distinction between correcting something that's made in error and something and changing and you doing something different because you change your mind. Precedent only has value if it's honored in the absence of mistakes. So it doesn't allow you to really just change your mind that, hey, we liked it before, but we don't like it now, because that would just eliminate what precedent is. Mr. Brady is correct that we basically essentially litigated this issue in the Falkowitz application. There was great concern at the beginning. We produced the precedent. There was discussion, there was deliberation, and there was a decision made. The same thing occurred in this application. I believe it was at the first meeting. Well, wait a second. No, I'm sorry. Let me back up. The precedent that was created in Falkowitz was a circumstance where the applicant came forward with a lawful non-conforming building, wanted to tear it down and rebuild it, but they had to prove that the building was substantially compromised structurally. And that really narrows the scope of your precedent here. You have not set precedent in every single case where somebody comes in and says, I'd like to knock down my non-conforming building and rebuild it. That's not the precedent that you have on board here. And this board was very careful in the first meeting we had, that at least that I was on, where you had concerns about the architectural report we produced. You sent us back. Gary went out, inspected with the architect, came back, and I believe everybody agrees that the report now shows that this building is substantially compromised.
Mr. Myro,
Yes.
excuse me for interrupting. That's not my understanding at all. My understanding of that report was if you were to demolish and rebuild, you would not do it on that foundation. So that report was generated in that realm. I didn't see anywhere in that report where it talks about this specific property not being habitable or being condemned or not being safe. What the conversation and the agreement from Mr. Thomasberger was, if you were to tear down, you would not build over that existing foundation.
Yeah, I don't read it the same way. My reading is that foundation is deteriorating. It is not to code. It would never support a building that would be built today. And for that reason, based on what public policy wants your buildings to be safe, there's a great deal of similarity on what between the two reports on what the board considered under Falkowitz and this one. But it was my understanding that the architectural report went way beyond that and said that this foundation is not to code. This building is structurally compromised. Not that it's not habitable. Those are two completely different questions. But this building is deteriorated to the point where it clearly does not conform to code. And if the building inspector probably could violate it for not being up to code if it wasn't legal non-conforming. So I don't read it exactly the same way as you do. I understand the distinction that you're making, but I don't read the report that way.
I think that what Andrew's trying to say is that, and I agree with what he's saying, there's no imminent danger to the people who are living there because of the foundation of the house. But if you were to tear that house down and rebuild on the same foundation, it's not a viable solution. You would need to create a new foundation.
Yeah, you would basically correct a deteriorating condition that does not conform to building code.
Right, but I'm not even sure that's relevant. I think it might be a moot point, because if you tear down the building, you're still tearing down the building, whether you build on a new foundation or the old foundation. So we're really discussing tearing down and rebuilding the building.
Well, but Madam Chair, Mr. Myro's logic is that the precedent is that this is a condemned building, that the foundation is,
Oh, is that what you're saying, Mr.
So-
Myro?
I didn't say it was a condemned building. I'm saying that under Falkowitz and under, I believe, some of the other cases, there was proof brought forth that the building was in a compromised position. Not condemned, not uninhabitable, but certainly not to code and certainly needing attention. That is, to me, is part of the precedent. And I distinctly remember Mr. Brady bringing this up, I think at the first meeting, that's what this board needs to see if we're going to be consistent with Falkowitz. And I don't mean to put any words in your mouth, but that's my recollection. And that's why we were sent back to the field, the architect and with Gary, and why the report was amended to come forth with some pretty specific detail as to where this foundation is clearly failing.
Jay,
I
I know
believe-
that that's
believe
what the
both-
discussions were before the board, but I don't actually see that within the decision of Falkowitz. So while I understand the distinction that you're making, frankly, I'm not sure that it's beneficial to you right now, because I don't see that in the decision.
Well, I'm sorry, it might not have been in the written resolution, but it clearly is in the minutes.
It might be.
It clearly is in the minute. We had discussions about this. The board, I think every member who was on that, who considered Falkowitz, would agree that there was a pretty unanimous consent that that building was failed.
I don't disagree that was
Alright.
the conversations that the board has. I'm just saying that in the decision that the board has, if this decision came up 25 years ago and was forward, maybe those discussions wouldn't be recalled. A board would first look towards the decision, and the discussion about the status or the safety of the building was not raised within that decision. And the decision is very thorough. I've reviewed it several times. But I just wanted to bring that up just to address Andrew's point, but I think I also was interrupting Craig, so I'm very sorry when I started talking.
I think I tried to interrupt you, so we can be sorry at each other.
Okay.
I think to Mr. Myro's point, that many of the members, it wasn't just me, but I think Mr. Abrams and Mr. DiVenuto also were very interested in getting a full readout, if you will, on the foundation of this current property. But because essentially there was that, if you want to call it institutional memory, and we had of the next door property and the detailed report that came through on that. So that's been provided. And maybe for the sake of clarity that Kelly's pointing out, it should be referenced in the decision so that there is something there that backs up the decision itself from a factual standpoint. Should this board move forward, I might add.
Certainly, if the board moves forward and approves this, it certainly can go into the resolution that the similarity in reports and the standard you required is similar, was essentially the same as what was shown in Falkowitz. That can be included as a finding in a written resolution if you do consider going forward on this application. But if I can just finish on this particular issue, this precedent is not something that's just limited to Falkowitz. This goes back, you're going back decades. So I think the board has to be careful, especially in light of the very thorough deliberations you did with Falkowitz, to make sure that if you're going to change your mind on this because of a mistake, I think it's got to be very close to a mistake in law and not in fact. So finally, I'm really having a little struggle here in a circumstance where an applicant comes forward, has proven that there's really is a significantly compromised building that's at issue. I really just feel that the precedent you've set certainly serves a legitimate public purpose, and that is to clearly make buildings as safe as possible. So I'm not sure really, I don't think you're really bumping up against a problem with fulfilling your duty to protect the public interest. And finally, the last thing is there were comments, last time we were here as to what the end product was with Falkowitz, and everybody was very happy with how that turned out. And I haven't seen it, but it seems like everybody was quite happy with the way it turned out. I'm not really sure where you've made a mistake in terms of setting the precedent that you have, which is to take these buildings that are non-conforming, to take these buildings where you're getting, they're being converted to a more restrictive use, and to certainly modernize and make them safer. So I'm not really sure where this precedence is doing violence to any matter of public policy, or certainly as to what the board has been thinking over the decades when they've granted when they've allowed this relief based on your precedent.
I think, Mr. Myro, I think a lot of it is, we look at it like when you had the two proposals there, we said, oh, well, moving it makes more sense because it's further back. Right now, what are you, 4 feet, 9 feet from the road, on the corner there. So it makes more sense to move it, but I think we're struggling between our hearts and our head, the law and what makes the most sense to us. I don't know, what does the board have to say about the proposal for moving it is off the table now, Mr. Myro? Is
Say
that
again?
you're taking the proposal to move it to the rear of the property off the table?
Well, it's my understanding that Kelly's advised that you can't approve it by moving it back and it maintaining a non-conforming use.
Correct.
So we don't have a choice.
Okay. So what is the board's pleasure here? What?
I think we've heard everything. I mean,
Well, this is public hearing, correct? Are there
Yes.
other folks that wish to speak?
Is there anyone from the public who wishes to speak to this application? Tim, you have anybody on Facebook or wherever?
Nope, nothing.
Nope, nobody. Okay, what would we like to do here? Do we
I
wish
think we
to?
should close the public hearing and make a decision after the meeting like we normally do.
Well, we'll need to,
Before you close the public hearing, I'd have one request here. If the board's inclined to be considering not following its precedent, I've submitted the Falkowitz decision, I believe, as part of my application. It is in the record, but I don't believe the minutes are in the record. We could do one of two things. I either would need an adjournment to supplement the record to include the minutes, or we could agree now that the minutes are included as part of the record on the Falkowitz seal, are included as part of the record. And if you can stipulate to that, I don't need an adjournment to go forward.
Mr. Myro, I wasn't on this board at the time of Falkowitz, so I am not familiar with the minutes or those conversations. So personally, I don't feel comfortable with that. If we would like to keep the public hearing open, and I could go through and evaluate those minutes, or whoever else is on this board, but I don't feel comfortable making that assumption because I wasn't here at the time.
I'm good with that.
Yeah, I don't think we remember what's in the minutes ourselves. I mean, I
No,
think
I don't know what I
there
did.
were pieces of what we discussed.
I don't know what I did yesterday.
Kelly, is Jay allowed to attach, or are we allowed to attach, keeping the public hearing open? Can we attach that to the application so that we can review further the Falkowitz decision and minutes?
If the applicant is, whoops, sorry, I accidentally hit mute in the middle of that. If the applicant is requesting additional time to make an additional submission for this board to consider, it would certainly be appropriate to keep the public hearing open for that, so that any members of the public who would wish to review that have adequate time to review it as well and give their comments to this board at a continued public hearing.
Okay, I think that's a good idea. Not
Mr.
only
Myro?
for Andrew, but for all of us to review.
I believe that's is that Mr. Myro's, I mean, we want him, we would need
Well,
him to ask for that,
listen,
correct?
I'm not, it's my job to kind of read the tea leaves here and see where we're going. I'm delaying this application further if I make that request. Listen, I think it's certainly, I think it's fair to everybody that we review, what happened in Falkowitz. I mean, I think it's obviously the one that's got to be weighing on your mind. And, certainly it's the closest in proximity, both distance wise and time wise. And you guys took an action on that application that I consider to be virtually identical. So if you have concerns, it's probably appropriate that you take a look at what you may or may not be considering to deviate from prior precedent before you actually may do that. Of course, if three of you are going to say you're not going to deviate, then I'm happy to go forward.
Madam Chair, I would like the opportunity to evaluate those minutes if they're available to us. And I would also like to further look at Falkowitz's decision to determine layout, floor plan, just make sure I haven't missed anything if possible.
Yeah, I'm getting a
There's
text from,
no problem with that.
I'm getting a text from my client. Oh, boy. All right, well, listen,
Jake, does your client want the public hearing adjourned for an additional submission? Or
Well,
are you
let's-
saying you're good with the record as it has been developed?
if the board is gonna, if the board has any inclination to close the public hearing and vote tonight, I don't know if that's your inclination. You obviously have 62 days after you close to take any action. I don't know whether you're inclined to take action tonight. If you're not, I'll ask for the adjournment.
Yeah, I'm not inclined, especially with Andrew wanting to get himself up to date as far as the Falkowitz deal. So
I agree. I
If there's no likelihood you're gonna vote, then let's adjourn it to June. I'll submit the additional information. Hopefully, we can close and vote at the June meeting.
All right, do I have a motion to carry this over keep the public hearing open, carry it over till June?
I'll make that motion.
And I will second it.
Okay, all in favor?
Aye.
Okay, so next month, so you will submit the minutes into the record, Mr. Myro?
I'll go through the Falkowitz file and submit anything I feel is relevant.
Okay,
But it will certainly include all the minutes.
all right. And could you get that to us earlier than like 2 days before the meeting? Like a week or two before?
Listen, I'm out next week, so.
June 9th is the meeting.
June 9th.
I believe
What's the
so.
submission deadline? Is there?
Jay, I would say that you would have to have it in no later than May 26th unless this board has a different policy.
All right, I'll
That's
work
2
on
weeks,
it.
that's at least 2
2
weeks
weeks, yeah,
before.
we need time to
give
look
you-
at it.
All right,
Yeah.
Well, I'm out all next week, so I'm back on the 24th. I'll see what I can do tomorrow. I can see whether I've got the minutes or not. And I'll do the best I can, but to get it by the 26th at the latest.
I would just also caution you that typically, while we may deliberate on a decision, we don't actually vote on it until the following month. So the likelihood that you'll have a vote walking out of June 6th or 9th or whatever the date is, I think the term would be slim to none, right?
Even
Well-
if I'm that persuasive,
Even if you're that persuasive, we typically vote to request council to generate a decision consistent with the board's deliberations, provide that for the following month, and that's when the vote takes place.
noted.
So just
Thank you.
just advising
it.
you of that.
I remember.
context.
I remember. Okay. So I'll get you everything I can by the 26th.
Appreciate it very much, Mr. Myra.
Okay.
Thank you. All righty. Good
Thank
night,
you.
Mr. Myra. Thank you. We'll see you
Okay.
next month.
Okay, bye.
Bye-bye. All right, next on the agenda, we have Valdez, continuation of public hearing for a special permit to permit a second dwelling unit for a family member, Priscilla Arias, pursuant to section 310-35 of the Village Code. Said property is located in the R1A zoning district at 20 Abrams Road in Central Valley and is known on the tax maps as section 226 block 1, lot 37.221. Is the applicant present? No. The applicant has requested, this was a request, she requested a postponement because she had difficulty getting the materials together for the meeting. So I would like to make a motion that we carry this over till June, where one, she'll either have the materials, or two, she'll provide us with an update on the progress of getting those materials, and be informed that if she doesn't do either one, that we would have to deny the application based on lack of information, because we can't make any decision based
I'll
on no
second that.
knowledge. Craig? Oh,
Would
you're
we-
voting?
No. Wouldn't it be advisable in that context, instead of denying the application, to advise the applicant to go to the building department and withdraw it until she gets such documentation?
Well, I think we withdraw the application till I thought we could just keep the public hearing open till she gets it. She said, possibly June, I don't know.
If what we're saying is we're putting a firm deadline on it and saying
No,
you're
no,
going to be
no,
denied.
no. I'm not putting a firm deadline. I'm saying she'll either give us the materials or let us know the progress of getting the materials. If she doesn't respond to us or doesn't show up or doesn't give us any information, then the application would probably have to be denied. In other words, she would be advised that she either needs to come to the meeting with the materials, send the materials ahead of time, or give us an update on procuring those materials,
Or withdraw the application.
or withdraw, you're right, or.
Right, and that's what I'm basically saying. Thank you, Andrew, is I don't want to see an application denied in this context. They should be advised to withdraw it so that it makes more sense for them.
Yeah, so we can
Because
tell,
if they have to resubmit, if they want to resubmit, then that requires a supermajority of the board, right? That's a different context. I'm saying it never got to that point. It should essentially be withdrawn, and they should be advised, get all your materials together before this comes to that. That's all I'm
Right,
saying.
I guess what I did make myself clear, I was saying that if she didn't respond in any shape, manner, or form, we would have no choice but to deny. In other words, if we keep reaching out and she's not responding, then it would, we would have no choice. We can't wait forever.
yes, ma'am, and we should advise her of that with the
Oh,
building
absolutely,
department.
yes. No, she was advised, I went to the building department the last time and said, and she wrote back and said, I'm having difficulty, could you extend? And I don't have a problem with that.
Yeah.
Okay, so if she is contactable, that's all I'm saying is.
Oh, yeah,
I'll
yeah.
Make sure that she understands that she should withdraw the application
If she
if
can't
she
get-
doesn't have it by a certain date. That way it's clear.
Kelly, do we need to set a date?
For the adjournment, yes, it does have to be set to a date certain. So I would say adjourn it to your June meeting. And if there's no correspondence back, we can assist in drafting a letter. We've done that on behalf of the planning board. It's just really to make sure that they're responsive to the request.
Okay,
So someone made the motion. I don't know who.
So The motion was made. Was
It
the
was
motion
made by Karen and seconded by Kevin.
All in favor?
Aye.
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 Okay, so we will carry this over till June and hopefully we'll either get an update or we'll get the materials from the Valdez applicant. All righty,
Okay, moving along.
all right. Next on the agenda, Yitzhak Stein Ideal Design, continuation of public hearing for an area variance based on a denial of a building permit by the code official to permit the expansion of a non-conforming seasonal dwelling. Proposed expansion of 87 square feet will exceed the maximum 10% square feet of the existing dwelling, 751 square feet pursuant to section 310-432.2, letter C of the Woodbury zoning code. Said property is in the R2A zoning district at 31 Springs Road, Carmel Park, in Highland Mills, and is known on the Village of Woodbury tax maps as section 216, block 5, lot 1.1. This actually is a public notice in error. Is the applicant here?
Yes, hi, good evening.
Oh, there you are. Okay. There's so
Hi.
many pictures here. You submitted a drawing to the building department, correct?
Correct.
With an adjusted drawing, which brings the extension that you wish to put on less than 10%. And the building inspector wanted to know. It was actually given too late before the public hearing notice went out. So what you have to do is you have to submit an amended application with the drawing. We have the drawing, but you needed an amended application.
Okay, so the application, the previous application doesn't show any specific measurements, any specific square footage from the proposed addition. So basically, the same application basically addresses the issue. So do I need to do a new one, or what is it for?
I believe, Kelly, he needs to submit, we need to renotice the public hearing because this was for the excess of 10%. And the new public hearing notice will be for the new dimensions, which is less than 10%.
I don't have the public hearing notice in front.
The original public hearing notice was because his request was an excess of 10%.
Yeah. So that, as you're saying, it was an error. However, this is not a greater variation from the code. It's actually a lesser variation from the code. So I would leave it to the zoning board to determine what you think is appropriate. The plan I don't know when the revised plan was actually submitted to the building department, but so long as it was there in enough time for the public to be able to view it, since that's what the public hearing is based upon. I don't know if you have any members from the public here that are here to comment on it outside of the applicant, but it's up to this board if you want to proceed with it. The only reason I say that you wouldn't necessarily need to correct the public hearing notice. Personally, I always think it's best to have the accurate information out there, but this is actually less. So the public would have been on notice for a request that was much greater. So this is actually less.
So we could close the public hearing this evening or no?
You could, if you so choose, if you go through everything and you don't hear any comments or you don't have any further, then you could certainly close it and deliberate.
Okay, what is the board's pleasure on this?
Madam Chairperson, this is
Yes,
Joe.
Joe.
The architect stamp was 6 May and it was received in the building department on May 7th. If
Yeah,
that has any effect on things.
Does the board wish to proceed with this evening, or do they want to wait for an amended application? Do you see any need for an amended application?
I don't.
I don't.
I also do not.
Okay,
I agree.
all right. Is there anyone from the public here to comment on this? So basically, I mean, if I look at the drawing, the original one was flush with the side of the building, went out, and then it's been now moved in slightly to create a smaller footprint of the extension. so it's less than the 10%.
That's correct.
Does anyone have any questions or concerns regarding this?
I'm good. Nothing's really changed except that
Right,
It meets the
it's just a
10%.
smaller, it's within the allowable.
right.
All right, do we want to close the public hearing on this?
I think we should.
Okay, do I have a motion to close the public hearing?
Is there anybody from the public?
I asked, anyone, I'll ask again, anyone from the public wish to speak to this application? Nobody's there, Kevin, so,
I'll make a motion, we close the public hearing.
all right. Do I have a
You want,
second?
do you want to ask Mayor Egan if there's anybody on Facebook?
There's nobody there.
Thanks, Tim.
I second Kevin's motion.
All right, Joe, thank you. All in favor?
Aye.
Aye.
Okay, so we've closed the public hearing for Mr. Stein. And Mr. Stein, we will discuss it at the end of this meeting. You're welcome to stay, or you can call the building department tomorrow to see what the discussion yielded.
All right.
All right?
Yeah, thank you.
All right, thank you.
Good evening.
Thank you. All right, next on the agenda is Ross. This is a continuation of a public hearing for a special permit to permit a second dwelling unit for a family member, Martina Espana, pursuant to section 310-35 of the Village Code. Said property is located in the R1A zoning district at 6 Carroll Drive in Highland Mills and is known on the tax maps as section 202, block 1, lot 46. Is the applicant present? Okay, this is an applicant who put in an application for special permit for a mother-daughter. Did not come to the last meeting. I went to building department, informed them. The building department twice sent notices to the applicant requesting information, more information. Nobody has gotten back to the building department. You want to give her one more month?
Madam Chair, if it pleases you, I think we adjourn it to next month and we let the building department know that the applicant either has to withdraw their application, provide the information that we need, just like any other decision. So I make a motion that we adjourn it to next month.
Second.
All right, all in favor?
Aye.
Aye.
Okay, so we will adjourn the Ross application till next month. And it's really up to the applicant what she wishes to do.
Madam Chairperson,
Yes, Joe?
this is a pre-existing mother-daughter,
Yes,
correct? Because I
Yes.
came up that this was inspected by the building department on the, excuse me, the 5th of February, 2019. So what was it, the last time when we met last month, you stated that we needed to get other information. So what is it that
well, we
they
don't
need to
have,
come up with?
what she gave us was drawings of each room in the home with the dimensions. However, the drawings didn't show which room or where the applicant's mother, I think it was the mother, family member, was going to reside. So it was, and I didn't at the time know that it was an existing mother-daughter. So we needed, we need a little bit more information, and the applicant needs to provide that.
So just want to clarify one thing if I could. I don't want to say that it was an existing mother-daughter. It had previously been a mother-daughter, but under the village's code in section
Right.
310-35
Yeah,
D, once it was sold to this new property owner, the permission, the special permit that this board grants for a mother-daughter is temporary. So once it's sold, that temporary special permit is deemed null and void.
right.
So there is no existing mother-daughter.
Right,
And what I agree with what you're saying. What was submitted were the plans for each room. But I mean, I couldn't tell if those were existing rooms in the house, if they were part of what was going to be used for the mother. So in order to demonstrate, that it qualifies under those regulations of 310-35, I agree that additional information needs to be provided for this board so that you can make an informed decision on the request. That was it.
All righty. So should we, so we're going to carry this over till June. Did we do the motion on that already? We did. Okay. So I'll let the building department know that she needs to, either provide the materials or withdraw the application until further, until she wishes to do it again. All right. All right. Next on the agenda is Marin, public hearing for a use variance to permit the existing accessory structure 16 by 16 foot storage shed to remain on a vacant unoccupied lot, whereas pursuant to section 310-11A, quote, no accessory building or structure shall be erected prior to any principal building, end of quote. Said property is located in the IB zoning district at 28 Falkirk Avenue in Central Valley and is known on the Village of Woodbury tax maps as section 226, block 1, lot 63. Is the applicant present?
Yes, I'm over here.
Oh, there you are. Mr. Marin, is that who you are? Yes. So my first question is, are you the owner of that vacant lot?
Yeah, I'm the owner.
Okay. So you built a shed on the vacant lot and now you find out that you can't have the shed there unless there's a home or something else there, principal. So you come before us for a use variance. A use variance is very different from the variances we've been talking about this evening. A use variance has 4 criteria, and you have to meet each and every one of them in order to be granted the use variance. I guess what you need to do is you need to show us that this property, that by not allowing a shed there would create an unnecessary hardship for you. And you would have to do that by showing that every use that's permitted in the zoning district for that property is something that you could not do. Basically, the 4 criteria, and I know the first one you wrote that it really didn't apply to you, but you have to show this for a use variance. You have to show that you cannot realize a reasonable return on the property. And you have to do real dollars and cents. You can't just say, well, it's very expensive, I can't do it, or whatever. You have to actually have dollars and cents shown on a piece of paper as to why you couldn't get reasonable return. You have to show that if we didn't allow the shed, that this is a unique, that the problem is unique to this property and doesn't apply to any other property in the district or in your neighborhood or anywhere else in the village. You have to show that it wouldn't alter the essential character of the neighborhood. And the last one is that you have to show that it is not self-created. And that's usually the one that trips everybody up. Self-created means that there's something that the shed is not allowed there, but you put it there. So basically you wanted that shed there. So in our minds, that is self-created. I don't know, use variances are very difficult to get. I don't know if we should even proceed since Kelly, I think that this use variance request for a shed on the vacant lot, I see it as being self-created because he wanted a shed there and he put the shed there and whatever. Should we proceed? Do we make him go through the other 3, especially the dollars and cents criteria, or knowing that it's a self-created and he has to meet all the criteria, or what do we do?
Well, I think you've done a very good job of summarizing use variances. I will give the spiel, I'll call it spiel, that I usually give in connection with use variances, really for the benefit of the applicant, because they are so hard to get and they're not granted easily at all. Frankly, it usually scares applicants off after I'm done describing them, but it's his choice if he does want to proceed. So I'll really direct this towards the applicant, but the advice is for the board obviously as well. So as the chairwoman said, use variances are so different from area variances, and the items that the board typically considers are either special permits, which they had a lot of tonight, or area variances where they balance 5 different factors and it's state mandated. There is no balancing when it comes to a use variance. A use variance is this board be authorizing the use of land for a purpose that's otherwise not allowed or that's prohibited under the zoning code. So here, having this accessory structure erected prior to a principal building is a prohibited use. And so that makes it a use variance. And there are 4, as the chairwoman said, there are 4 elements to the use variance test. And I will read them to you exactly as they are, and you can decide after that if you want to proceed or not. And the first is the applicant cannot realize a reasonable return, provided the lack of return is substantial as demonstrated by competent financial evidence. 2, that the alleged hardship relating to the property in question is unique and does not apply to a substantial portion of the district or neighborhood. 3, that the requested use variance, if granted, will not alter the essential character of the neighborhood. And 4, that the alleged hardship has not been self-created. So like we said, this is very different from just balancing different factors about the impact on the community. This is that you actually have to demonstrate each and every one of those. And when the chairwoman referenced dollars and cents proof, that's what the court references when they have these matters before them, is that there has to be dollars and cents proof, which isn't just, you calculating something on a piece of paper. Generally that involves an accountant and having all of that there, because you need to consider the different uses that are permitted in that district and whether or not you can realize a return. I recognize that your house is in a different district than this property, because your house is in a residential district and this property is an industrial, but it might make it even more difficult, or your accountant may make that connection that maybe it's simpler. But they are very, very rare to be granted, because most applicants, they can't prove that first element by going through all of the uses by dollars and cents proof. And also, like the chairwoman said, because the majority of the applications are self-created, and it's self-created because you're the one that's asking for this. And it's not that this was already up there and then the zoning code changed on you or anything like that. These provisions were in there. So there's really 2 paths that can be gone down here. And the first is what the chairwoman was getting to, is requesting additional information from you to, by clear and convincing evidence, prove each one of these 4 factors. And the other is she's trying to be very diplomatic and helpful in her description. So that to the extent that it's helpful for you, I have reviewed your application, and from a legal perspective, I'm of the opinion that the hardship has been self-created. However, you have the opportunity to provide evidence for the board to consider and for me to consider to further advise the board that it has not been self-created. But as far as the application right now before the board, it's being viewed as your request to have an accessory structure on this property without a principal structure, which is prohibited under section 31011A. And that's why you're requesting it, rather than that was there and things changed on you. So like I said, normally after saying all that and saying that you have to be able to prove all of that, people sometimes reconsider their applications because it's really, really hard to get a use variance. But I think it might be something that, you need to think about, you need to consider. And whether or not you want to spend the time and the money to get all of that evidence together, that's your call if you want to proceed with the application, or you can choose to withdraw it and relocate the shed. So that's my advice to the board and my explanation to the applicant. I don't know if anybody had any questions, or did I scare the board off too?
Nah.
We don't scare easily.
Okay. I'm sure Kevin's actually probably heard me go on and on for years.
Too many times.
Oh,
No
That's a
such
good
thing.
thing.
There's no such thing.
That's a good thing.
Does the board have anything they wish to comment on or say, or?
Well, the only thing I have to say about this is, it looks like a little house. More than a chicken coop.
Well, it's a shed. It was,
More than
I
a
think it
shed.
was a chicken coop, but it's 16 by 16. That's not a house.
I could be comfortable in that.
It's a tiny house.
Just give me the TV and the clicker. No, I mean, but I understand what he's in a tough spot with this, because what he wants to do here really can't be done.
Yeah, it's,
But it still looks like a house.
well, it's a nice looking shed.
I know, but with the cost of lumber today, it'd be cheaper just to get the eggs in the store.
Mr. Maron, do you have anything you'd like to say or ask, or?
No, nothing. We're not gonna go through. So how long we have to tear it down?
That I don't know.
Well, what I would say right now is, I think it would be appropriate for tonight's purposes for the board to continue the public hearing until the June meeting. And then the applicant can, absorb stuff, this was really just kind of brought to his attention today. So he may want to look at it, determine whether or not yes or no, he wants to proceed. If he determines not to, he can withdraw the application. He has a month to do so. He just needs to let you know. But then he has some time to really digest what was just presented to him.
Did you
So-
understand that, Mr. Maron?
¿Cómo?
We have any chance to the.
Everything I said.
So we have to, any chance to wait until June for the last decision?
So, Mr. Maron, what the attorney said is, we're gonna keep this public conversation open until the June meeting to give you the opportunity to understand everything that the Kelly went through with you tonight, and you can determine at that next meeting how you want to proceed. You can let us know if you want to continue or if you want to withdraw the application.
That should be in June, right?
Right. In other words, we're trying to give you some time to digest what was said this evening and, make an informed decision as to whether you wish to pursue the application or whether you would prefer to withdraw it.
We're gonna wait until,
I would like to make the motion then to keep the public hearing open till next month, till the next meeting.
Second,
All in favor?
aye.
Okay, so Mr. Maron, we'll see you next month, and you let us know what you have decided to do.
okay, thank you.
All right, thank you. All righty.
And to the extent that it's helpful for the board, I think it might be useful in this situation if I just put together a brief letter or something like that to the applicant saying, these are the elements of the use variance test, and the board is requesting information to support those elements if you choose to proceed, just so that it's clear. Like I said, a lot was said tonight.
Yeah.
Sometimes
that's
it's hard
true.
to
Yeah,
digest
I
all at
think
once.
it could be very overwhelming.
Yeah. Okay. So I'll send that to the building department, and then the building department can forward that to the applicant.
I appreciate it, Kelly. Thank you. All right. We do not have a building inspector's report, but we have one public hearing that we closed, so we can deliberate on that. And that was the I don't even think I'm saying it right, Stein application. This was the applicant who wanted an addition on a bungalow that was exceeded the 10%. We didn't have the authority to grant that, so he amended the application to less than 10%. Has everyone looked at the revised drawing?
Yes.
Okay, does anybody have any issues that before we go over the 5 questions? Okay, let me go over the 5 questions here. Will the granting of this variance produce an undesirable change in the character of the neighborhood or create a detriment to nearby properties? The applicant says no. It's just a small box out of the existing unit to add some living space as done by other units. The unit outline stays the same use, same character.
I would agree with
Agree.
the applicant.
I agree with that.
I agree.
Okay, we agree. Number 2, can the benefit you seek be achieved by some other feasible method other than the variance? No, the property is existing non-conforming. Yeah, I mean, basically, you can only make it smaller, can't make it any larger. You know,
Right.
so. Number 3, how substantial is the variance that you are requesting? It's just a small box out of the existing unit. So the outline stays the same use, same character. It's less than the 10% that's allowed. So I guess it's really not considered substantial.
I agree.
I
Okay.
agree.
Number 4, will the granting of the variance have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district? No, it's just a small box out of the existing unit to add some living space. The outline stays the same use, same character. I think you had a little rubber stamp. I agree, it's not going to cause any
Yeah, I agree with that.
difficulty there. And number 5, is the alleged difficulty self-created? No, we're looking to create some more living space within the unit. I disagree.
It is.
It almost always is self-created, but that doesn't preclude us from approving the variance. So what do you want to do here? Looks
I
like
think we should have our attorney draw a favorable decision.
a decision
the
based on, oh, come on, Craig, you're the one that knows how to word this.
Andrew was doing it really well the last time we had one, so. So have we done secret, or is it necessary? Do we declare it a type 2 action?
I believe
not-
council,
I
I
don't
believe
think-
council advised us that we are the, what's the proper term, Kelly?
It's a
We're the-
type-
It's a
the
type 2
lead.
action, and so no further seeker is required. It was also referred to county GML back in February, and you didn't receive anything, and clearly more than 30 days have passed because it's no longer snowing. So you do have jurisdiction to act.
So I would make a motion that we declare this a type 2 action with no further secret review required.
I will second that.
Okay. All in favor? I don't think we need to all in favor.
Aye.
Aye.
Who's going to do the nice wording for the draft decision?
So I would like to make a motion to advise council to draft, based on the conversation here this evening, a favorable decision that we could then vote upon that favorable decision at next month's meeting.
I'll second that.
Nicely done.
He's been studying.
I've been
see
All in
practicing.
favor?
Aye.
Aye.
Okay, so Mr. Stein, next month, we will read and vote on the decision, but it looks like it's good to go. But you really can't start doing anything till we actually vote next month,
All right, thank you.
okay?
Thank you, everybody.
Thank you,
All right.
Mrs. Stein.
Thank you.
Thank you. Have a good night.
You too.
Take
Thank
care.
you. Before we adjourn, which is next on the agenda, this is Joe's last meeting. He is not going to reapply or has not reapplied for a zoning board member, and I would really like to thank him, Joe. I appreciate all the research that you've done, all the attention to detail, your professionalism, everything. It's been a pleasure to work with you, and I wish you nothing but good things, good health in the future. So
Thank you very much.
I couldn't agree more.
Okay, we're gonna be sorry to see you go, Joe.
Yeah.
Well,
And
Joe,
I'll
I've
get-
known you from being on the board and being in the public. So this is going to be a loss. It is.
Yeah,
sometimes.
it is. And
I know
love
I'm
you.
just here for tonight and I haven't seen you in a while, but it's going to be a loss. Thank you for your service to the village.
Yes, Joe, thank you very much.
Thank you all very much for your kind words. And I'd like to say good luck with your decisions in the future.
We'll need that. Thank you, Joe. All right, do I have? a motion
Madam
to
Chair,
adjourn?
before
Yes, okay.
before we adjourn, what can we do, or what do we do about executive sessions?
You mean
Because I
very
think we-
virtual? Yeah, it's a good question.
In
don't know.
virtual, right?
Yeah, I don't know.
So if you would like to go into executive session, you would, I think I have an idea as to what the executive session is about, but I could be mistaken. But you would go into you would make a motion to go into executive session to discuss the potential hiring or firing of an employee or consultant. And then you would have Tim kick everybody out. And as part of that motion, with no intention to take any action after that executive session. So he can kick everybody out. And since Tim is the host, you would welcome him with open arms into the executive session so he can sit there and you don't have to end the meeting. However, if you don't feel comfortable with that, you can make said motion. If it's something you need attorney-client advice for, I can set up a separate Zoom meeting and send that to you in a minute if you would like that. So it's up to you. I'm not specific as to what you're looking for, so it's either executive session or attorney-client advice. So whichever you think based on what you're thinking about.
And I'm not necessarily saying to do it now, right? Because we do have as part of our agenda, executive session at the beginning of every one,
Right.
but we,
Oh,
with
weird.
it's a little, maybe it shouldn't be there. That's a separate question. The context here is probably not one we need to discuss tonight, but I think that it would probably be worthwhile in an attorney-client perspective for all of us to sort of agree that the code clarifications that we addressed earlier, that were brought up earlier, to refer those to the village board and you know, whatever is entailed in that. That was one conversation I thought would be valuable. And then there may be others as well related to matters before us.
Okay, well, one thing I would say, and this is without having obviously any attorney-client or executive session discussion, if this board comes across code provisions that you would like the village board to take a look at, you can certainly make a motion to authorize me to draft a letter to the village board identifying those provisions and requesting that the village board take a look at them with an explanation as to why. I say that actually, I see Chris Gerver's online. We actually just did that with the planning board, maybe last meeting or the meeting before, where they stumbled across a provision that they thought this should be taken a look at. So that's an option too. If you wanted to discuss that further, obviously you don't need to make the motion tonight. It would just be, you know, that's one way to proceed. Just trying to give
Okay.
you your options.
Yeah,
here.
no, that makes sense. That makes sense.
But the executive session is important for conversations of, you know, retaining personnel or having conversations like that. Do we have the time to wait until next month's meeting to have those kinds of conversations in executive session, Madam Chair?
Well, yeah, I think we do. Right, Kelly? I mean, if we have an executive session at the beginning of the next month's meeting,
You do. Why don't I do this? Why don't I send out an email right now by Zoom to all of you? Hang on, I just want to make sure I have everybody. It would be Karen, Craig, Kevin, Joe, Andrew, Jess. So I would send it out to you guys and we'll have a brief attorney-client meeting to discuss a couple of issues. And like I said, it will be brief. I won't take up the rest of your night. So why don't I do that? And then we can address a couple of these so we know where we're going.
okay,
Is that okay?
that
Good
sounds
idea.
good.
So on that basis, I'll make the motion that we adjourn the meeting and enter into an attorney-client meeting.
I'll second
Okay.
that.
Aye.
Are we going? We're adjourning the meeting, right?
You're adjourning the meeting. I'm
Yeah,
going to
but-
send you a separate invitation for attorney-client
Now?
Yes.
right now.
Oh, okay. Where are you gonna send it to?
Your
Your email.
email address that I sent the other stuff to, is that a good email address or?
Yes, ma'am.
Not for me, because I don't know how to get back into it after I set it up.
Okay, I actually think I have 2 email addresses for you. So hold on, let me check.
And I'll tell you what, if it's easier, just send it to everybody and I'll forward it to Kevin.
Okay. I think I have an older email address for you, Kevin, but let me send it out. And then Craig, you make sure it gets to everybody.
Use
Okay.
I have to call, I
use
have to
Joe's
call
Gmail
Jess.
address,
Thank you.
Ellie.
I'm
You-
sorry.
Use Joe's Gmail address, not his village address.
Oh, I think that's the only email address I have for Joe is the Gmail.
Oh, good.
Sorry.
That's the
my
one that
Gmail is
definitely
the
works
best,
for
too.
him.
Okay. I will send
Alrighty.
it out within 30 seconds.
All right.
Thank you.
Kelly.
All right. See you soon.
Bye.
Bye.